Key, Element and others.
Yes.
Good morning. Can I mention 2 points of housekeeping? Oh, I'm sorry.
I wasn't going to point it out, but
Sorry?
I wasn't going to point it out.
Well, you could have just said that you couldn't hear me, and I would then have been like the novice, bewildered for a while until I realised why. I do apologise.
Oh, that's much better.
Thank you.
Yes.
I'm much more audible, I'm sure.
You are.
Can I mention two small amounts of housekeeping?
Yes.
The first is that I think we've passed up to you copies of the judgment I referred to of His Honour Judge Taylor very recently, 26th of February. I don't need to take you to it, but you wanted a copy of it.
It's my fault I asked for it. I just felt I would like to know.
And I understood we hadn't appreciated that there was a desire to have hard copies of the transcript, but those are being printed and will be available for you in the course of the morning.
My clerk's actually printed one off for me, so I don't need another one. Thank you.
It's really, right.
But I am clerkless, so I would very much appreciate it, but no rush.
Right. Well, it's in transit. So I was reflecting overnight about examples, and I know I'm going back slightly, but I'm conscious of my time. But actually, I want to take you to an example that's in our skeleton. But actually, by walking you through it, you can see the underlying material, the problems that arise in the way that the tribunal has dealt with training materials, and to take my Lord Justice Underhill's observation, what does it matter? I think you might have put it in slightly less parochial terms, slightly less.
Yes. What are the practical consequences?
Yes. To do that, can I take you to the supplemental bundle, the main supplemental bundle, and it's volume 3, and we need to go to page 903.
Thank you.
And you'll
Tab 56. This is Mr. Jones again.
This is Mr. Jones, yes, who worked in the ambient distribution centre.
Does he have a job title?
He's a warehouse operative.
I thought he was an assembler. But is that
That's
something
what he
different?
was doing. I think his job title was warehouse operative.
Warehouse
The work he was doing was assembly.
Right.
I mean,
That is what you do in warehouses. You get an order and you go around the warehouse and pick up all the bits and put them in a cage.
Yes, that is. There will be people doing other things, but that's obviously the core activity.
Yeah.
Is
I know you could. It's more elaborate than that. It takes 100 pages to explain what it means, but that is effectively what his job is.
Yes. At 10, and we've looked at it before, but at 103, these are the closing submissions. But you'll remember the structure of how we got to this particular point in time. Can I then take you just onto page 911? Sorry that in the hard copy it's not always easy to read. And now this is part of an entire section that I'm sorry, I said 911, and in fact I should have meant 907. I do apologise. This is part of a section that begins at paragraph 6.095 in the left-hand columns and continues for a number of pages through to the left-hand column 6.125, and it's dealing with how Mr. Jones stacked the units of the delivery as you described it. He went round the warehouse, and if you look at 6.11, you'll see that part of the job description for him, prepared by the respondents, said he worked out in his head what products were likely to have to be stacked in the cages later in the assignment. So he's been given a task to stack, and he works out in his head what products will have to be stacked later in the cage, later in the assignment. and at what point in the assignment he reads those particular products. And if you then look at the right-hand column, the far right,
far right column.
far right, so you can see that the claimants want to delete this. And in the far right-hand column, you can see there's an explanation about the evidence, these are the closing submissions, pointing to the witnesses of the managers.
This is your response, the far right-hand column.
Yes, in
Yes.
closing submissions,
Yes.
about the evidence of why it was that Mr. Jones did the thing being described in the left hand. And essentially, and we'll see it a little bit more closely later, what's being described is, as a skilled assembler, having worked on the job and developed skill sets, he didn't slavishly follow what he was being told on the arm-mounted computer. He adopted a more sophisticated way of working that enabled him to do it more effectively and quickly. And if you go to 6.22, so 6.122, it's on page 911, you can see that it perhaps more simply put, in terms of the way it's being described, if you see again in the left-hand side, by 6122 it says, in order to mitigate against or remove the risk caused by awkward shaped and heavy products, when completing a single store assignment, the job holder exercised discretion based on his experience, what he knew of the range and nature of the units to be assembled during the assignment where necessary to place the units into cages, other than as instructed on his arm-mounted computer. And if you look at the right-hand column, you can see, referencing to the evidence of the managers, Mr. Matthews and Mr. Evans, it's referring to the fact that as a skilled assembler, he had adopted a method of working that saw what was going to be coming for stacking and planned how to do it more efficiently to move for the purposes of the cage. So that's reflecting how he did it. And if you look at the point 4, you can see the right-hand column, you can pick up that phrase, this was a method used by skilled operatives.
Sorry, where are you now?
Sorry, on the right-hand side, you see the 4 bullet points from the evidence?
No. Oh, no. Which page?
I'm
Same
sorry,
page.
we're on
They're not bullet points,
911.
numbered points.
Oh, number points. Weights are not the only relevant consideration. That one?
On 911,
Oh, 911.
on
I'm sorry.
6.122, on the right-hand side, do you see the cross-referencing to the evidence?
Yes.
And you see 4 says, while such stacking could show up as an error, if audited by the third-party accuracy checkers, it was a method used by more skilled operatives. And then there's a quotation from the evidence. This is not what starters are taught to do in training, but it's a way of working that's employed by more skilled operatives. So,
And was allowed because of the benefits involved.
yes. So here's someone who's doing this particular pattern of work. And I should say, in this section, there weren't many, but there were paragraphs that were agreed by the claimants. Can we then go to the judgment? And if we go to the judgment, it's paragraph 247, which is on page 729. That's volume 3 in the core bundle.
So 247 of Appendix 8, is it?
That's correct, yes.
3 of the core, but you say page 247,
No,
No,
paragraph.
paragraph 247, page 729.
729.
Should be volume 3, I hope. it's the beginning of a short section. Actually, it's 247 through to 251. And the subheading is paragraphs 6.95 to 6.127 of the job description, Mr. Jones. So the section that I've just taken you to, including those particular paragraphs. And what you see there is at 247, they say, we thought the work of stacking in ambient DC was definitively stated in the documents to which we referred at paragraphs 58 to 66 above, to the extent that what was in those paragraphs 6.95 to 6.127 of the EJJ for Mr. Jones differed from what was said in those documents. What was said in those documents had to prevail. So if you're the independent expert looking at this, what you're being told, well, have they found, or the parties, what have they found about the disputes in relation to the points identified? It seems to be, well, here's a group of documents over here, those are your answer. And you can see that they refer back to 58 to 66. And just to draw your attention, you can see, before we go back to those, at 2.49, they're specifically referring to
249, yeah.
You can see they're specifically referring to the paragraph I took you to about the way that Mr. Jones worked more efficiently, working out in his head. And they say that that was directly contradictory to the words set out in the documents above the training material. And
okay, we do have to understand that with 250, so, it's quite difficult to follow all these cross-references, but they qualify what they've said in 249 and 250, don't they? Nevertheless.
yes,
Okay. I'm just up to you, but
no, at 250 they qualify it about the particular paragraph at 6.122, but they go back to the principle that the better description is in documents.
that's 58 to 60, is it?
Yes, and we just need to go back to.
Sorry, is that 5860 of the judgment?
Yes.
Yes.
And you
okay,
find it, paragraph 5860, page 681 in the bundle.
Oh. Not at 614. Okay, sorry. So sorry, I thought I found it, but I obviously haven't. 681.
Yes, another confusion is because they do appendices and they number the appendices separately.
Yes, I see.
You see the same
no, I
number
understand. Thank you.
in different places. 681
Yeah.
is where in Appendix 8, under the heading stacking of cages, you can see that from 58 through to 66, they refer to training documents. And there are 10 training documents that they refer to in, and in fact, all of the ones, I think with the exception of one which they say is superseded, are in bundle 1 of the supplemental bundle. We'll look very briefly at them, but they're in bundle 1 they occupy pages 209 to 257. And sometimes they're referring to a particular quotation, but if you look at paragraph 64, on page 682, paragraph 63, you'll see that they're referring to information cards. Those are typically mainly pictorial. And in 64, you can see that they're referring not to a single page, but they're referring to 2 to 8 pages, 2 to 8 of a document in the training bundle. And just before we leave it, well, I'll just take you to show the nature of what's being looked at 66 at the bottom of the page, they refer to similar guidelines, but without the helpful depiction of the traditional game of Jenga in another training document, D9239, and they say, relating to fresh distribution centres, the documents are entitled Know Your Stuff for Fresh Assembly, Product Handling and Cage Stacking. So they're actually referring to a training document for a distribution centre that Mr. Jones didn't work in. And in fact, they're referring to a distribution centre that dealt with...
Which one is for a different distribution centre?
That's the one at paragraph 66,
Right.
D9259. You see it says fresh distribution centres. So that's, it's fresh food rather than ambient. He worked in an ambient distribution centre. So they're inviting, they're saying that this is, in the paragraph we looked at, this is definitive, but we've got 10 documents, and some of which extensively cited, and a document that doesn't actually apply for any training to the work that Mr. Jones does. And in fact, that document relates, when you look, I'll take you briefly to a page, you'll see that it deals with the stacking of bananas, bread, in trays and dollies, none of which formed part of Mr. Jones's work. So is that in his training? Because he wouldn't have been trained in it. It's what the independent experts have been invited to look at as being the definitive conclusion about those paragraphs of findings. And just so you can see it, if I take you back to the supplemental bundle, and if you look at page 210 in the supplemental bundle,
Sorry, to which bundle are we on?
I do, it's volume 1 in the supplemental bundle. It's the one I took you to with I took you to that because that is the example of one of the training documents which they make reference to, which they referred to pages 2 to 8 about the document called Know Your Stuff for Grocery Non-Food Assembly. And so you can see in that document.
So sorry, which paragraph are we on? Page 210?
210 of the supplementary bundle should be a document that's headed Know Your Foodstuff Grocery Non-Food.
Oh, sorry, I thought you said bundle.
Apologies. It's supplemental bundle volume 1.
Sorry, core one. So sorry. I thought we were up to. It's not the core supplementary bundle. It's
No, the main supplementary bundle.
Got it. Sorry to keep everyone waiting. 210.
Yeah.
Yep. I have it. Yep. Thank you.
Yes. So I'm sort of saying this is, other than individual quotations, this is a document that they're saying is definitive because it's the trainer's guide. It's got trainer's notes, and they, including pages 2 to 8 of this, that's the internal documentation. Pages 2 to 8 will begin, as I said, at 210. So the IEs for the parties, to try and understand what's being found, have to take the incorporation of that document. And that's why I said yesterday, when the IEs received the judgment and the supporting document, that's why they received the 9,000 pages of 19,000 pages of training documents because of the incorporation of that process. And just to make my point good about them adding in material that is completely irrelevant when you look at Mr. Jones, if you turn to page 633,
Which bundle are we in now?
same bundle, I'm sorry, I haven't changed, same bundle.
Page six, well no, 633 is a different bundle.
Oh, I do apologise, I mean 233, I'm sorry.
233. Know your stuff for fresh assembly.
That's correct. So this is the document that, as I said, didn't apply to Mr. Jones, but they've included in that list in the definitive, what they say to be the definitive position in relation to assembly. And as I say, you can see here that it's identifying at the top of the page how you deal with the stacking of bananas and fresh bread. And this is the level of detail that we only need to know in passing. It's also talking about those being in trays and on a dolly, and those weren't the ways that ambient stock was assembled for Mr. Jones. And if you just go back to, in this bundle, 229, you should have a document that's headed Cage Stacking Guidelines. And I've only gone to this to show you that part of this problem of the incorporation included not only irrelevant material, but also the need to look at visual material in relation to the exercise of determining how one dealt with things. And this is how they resolved the factual disputes that were itemised in that section that I took you to. And in doing so, they've rejected the manager's evidence about how Mr. Jones had a more sophisticated way of working than the training. Now, if you're dealing with the generic about the general training of a warehouse operative doing assembly, well, that's where the training material might be a touchstone. But what we're looking at is what Mr. Jones did. And they use it as a mechanism of disregarding the evidence that they had about what he actually did. Going back to the fundamental point that they're completely disregarding the primary legal structure of what they had to resolve. And I made the point yesterday, but just if you'll echo back, you saw I gave you an example yesterday of Mrs. Worthington having training documented included that referred to a pallet truck and a ladder that she didn't use. This is at a level of detail that's extremely difficult to demonstrate to you on the findings. But because the tribunal were engaging with the training documentation at an abstract level, rather than saying, what are we actually looking to find people have done, they cross-refer to training material that relates to different sizes of stores, disregarding the particular store that an individual claimant may have worked in. So there's training material being referred to that would apply to large stores, but wouldn't apply to express stores as they look at that broader picture because of that erroneous approach. And So I appreciate it's slightly irritating to have to go through that particular process, but I hope it sort of demonstrates that particular problem. And I yesterday, I think if I can keep you in volume 1 of, sorry, apologies. If I can take you to volume 3 of the supplemental bundle and just take you to page 914.
Which tab is that?
It is tab 56.
Oh, yes, we've been here before.
We have, and I didn't really make it clear yesterday, just so I thought on reflection. So I'm just going to show you the touchstones without going through it in detail. Just so if you remember, the issue was this. Mr. Jones used a lollop, battery powered, to collect the stock. And at paragraphs 6.232 and just over the page to 6.235, they're addressing changing the battery on a lollop if it ran out of power. And specifically at 6.235, if it happened to run out of power in the middle of the assembly of your assembly of an assignment. So you haven't finished it, but you're halfway through with cages that are loaded on your lollop. And the evidence was that in those circumstances, he would need to take the lollop to where charged up lollops were and swap it, which would mean taking the cages off, lower the arms, but some manoeuvring of the cages would be necessary. Now, by the time we got to closing submissions, all of those paragraphs, 233, 234 and 235 had been agreed between the parties. So between the parties, there's no issue.
You're wrong, but where do we actually see that?
You see it in the judgment.
You see the claimant has said delete, then for reasons of evaluation.
Yes. If you look at,
and then we see your submissions as per MH, whatever that means, and then Mr. Matthews confirms, but that doesn't show agreement, does it?
no, but where I took you to yesterday, if we go to the judgment, and in the judgment, this is back to volume 3 of the core bundle, and sorry, it's 737. Do you have paragraph 283? I did take it to you yesterday, but I don't think I made it clear to link it back to the schedule. If you look at 283, the very beginning of this records the fact that by the time of closing submission, so even beyond the document you've seen, 235 had been agreed. So all of those passages that I've just taken you to that contemplated him changing lollop mid-assignment and there being some manoeuvring of cages were all agreed. And then what they do is that they look at the training material, and they look at the training material, and I'll just give you the references there. They look at the training material in the following paragraphs through to in particular 288, and they say, well, what's been agreed here seems to be inconsistent with what the training documentation shows. And the training documentation shows that you shouldn't have a situation that you need to manoeuvre the cages off. If your battery runs low on an assignment, you should take it to the loading bay and just leave them there. But having seen the training documents are inconsistent, despite the fact the parties have agreed this, they, if you look at 290, conclude, well, if the parties, if that is what he was doing, 232, now an agreed paragraph, that was not an unauthorised way of working for the purposes of the Equal Pay Act, for the rules. So although they've agreed it, suddenly it doesn't become part of his work. And if you look at the question of why does it matter, I left you with this, I think, yesterday just before lunch. 294, paragraph 294, page 741. You can see how this then taints back the case, because at 294,
Paragraph, you say 294.
yes,
Yep.
They say, well, they conclude that because it had been the respondent's case now agreed that this had happened, it undermined the credibility of the respondent's case about
That
their
was
work.
agreed.
So we look at what's actually done. It's eventually agreed, but the training documents become something on which they conclude our evidence is unreliable from the managers. And that obviously that reflects back on other exercises. And one of the criticisms that's made is that the managers aren't referring to the training documentation. Well, that's because the case was presented on the basis of, as the tribunal is critical of in their first judgment, not the training documentation, but what people actually did, because the case had been prepared by everybody on the basis of the law, rather than what we say is the misdirection of law that the tribunal found.
Could I just ask, with these two examples you've given us this morning, were either of them revisited in the first reconsideration?
They are.
I don't want to. You've got limited time. I don't want lots of details, but in principle, I want to know if they are. And then perhaps later can give us the references.
Yes, I'll give you they are in certainly the one I've just taken you to is, and there is an acceptance, having seen a video, that there is manoeuvring of the cage, but obviously that doesn't change on one level the problem that they've already relied upon this to undermine the credibility of evidence in the first case.
I don't want to straight you up, but if at some point you could just give us the page references in the first reconsideration for this and the other, if it was reconsidered.
Can I leave that and we'll get that for you? That although I would say generally the approach of the reconsideration is to, as I think took you to yesterday, consistently to refer back to the training material. They never change their approach in that respect. So I was going to take you back now to the appeal on the point I left yesterday, which was ground 4, which was failure to make findings on the training actually received. And there were two elements to our appeal about that. The first is very much linked to their approach of looking at the training that applied, although we say across the piece of that, determining whether people had actually had that training. And the second thing was an appeal about how they dealt with mandatory training. And if we just go to the employment judgment, go to the tribunal judgment, we're in volume 1 of the core bundle, and we find it at page 252. So this is the first judgment of the Employment Tribunal.
So which page did you say?
252, volume 1, tab 16. There's a heading, training documents and manuals, and from paragraph 75 to 76, there's a two long quotations from the closing submissions of my learned friend, Mr. Bryant, for the Harcus claimants. And then at the end of that passage, in particular at 87 and 88, we have their conclusions.
So which page?
So that's 258.
Yeah, thank you.
They say, given our conclusions stated in paragraph 75 to 78 above, and I summate those because they are the same approach. They're saying we look at the training documentation as what the job required. So that's the articulation. And they then conclude, given our conclusions that we're looking at the training document as the employer's requirement, we saw no good reason to make determinations about precisely what training the sample claimants and their comparators had actually received. Well, you know, as I've indicated, therein lies a specific problem, because if you've got training document across the piece, you don't know whether or not someone has been trained on a particular element if they're in a location where they don't need that training, unless you decide what training people have had. And then they conclude this. Having said they don't need to, they then say that they do. At 88, they say, the exception would be the question whether an employee had received training would be material if the training had led to a determination for whomever that the employee was competent to do the thing to which the training related, and the respondent would or could not permit that thing to be done without such determination. We had in mind in this regard to be training the thing to be done with such determination. So we had in mind in this regard training to be a forklift truck driver. Thus the question whether a comparator had received that training was material, but we could see no other training in regard to which you would need to make a specific finding of fact of that sort. Now, we see that as them saying, well, we don't need to make any findings at all, but we do need to make findings if there's something which is a mandatory need to be trained in order to do something. And if you're operating a piece of manual handling equipment, like the lollop, you can't use it unless you've been specifically trained in its particular use. The tribunal, in their substantive judgment, make no findings about specific training that the comparators had. And we had a specific appeal that that related to the fact that there was copious evidence about specific training that people had to have by way of mandatory training in order to do the work of the comparators. And could I just take you to the supplemental bundle, and it's volume 4 of the supplemental bundle. I'm not sure if I've got a tab for this, but it's page 1145, which I think will be right at the back of that bundle.
One 1145.
1145. And this is an appendix to the skeleton argument for the EAT against the tribunal's judgment.
Who still has an argument?
Our skeleton argument. And what it set out was, and you can see it begins at 1145 and runs right the way from the following pages all the way through to page 1167. It cross-references the evidence that the tribunal had in relation to mandatory requirement training, including refresher training for the comparators. Now, the tribunal made no findings about any of this, even though at paragraph 88, this was material that they thought they would make findings about. Can I then take you to how the EAT dealt with this? And to do that, we have to go back to the core bundle. And in the core bundle, it's page 138. Well, it's volume 1, and I'm sorry I didn't give you the tab, but it's 138. So we're in the judgment of the EAT. And here you can see at paragraph 164 on page 138, Mrs. Justice Stacey deals with our appeal about these 2 points of the tribunal's decision, and she refers to paragraphs 87 and 88 and cites them there. And at paragraph 165, that's the next page, and that's page 139, you can see in the first paragraph, sorry, in the first section, second sentence, she refers to their conclusion that they don't need to make any findings about the training that individual claimants and comparators have had, and says, read in isolation, 87 does appear to be not only surprising but wrong. The extent of a job holder's training is plainly a fact relevant to the equal value question. I took you to that earlier. That's what Brunhofer says. And then she continues with her analysis, and we can see at paragraphs 167.
Just before we leave 165, she says it's not for this tribunal to interfere with a finding of fact made by a tribunal that spent as much time considering the evidence. Which finding of fact is she referring to?
Well, that's the point actually that I'm making in relation to it, is that she reads the paragraphs that I've just identified to you as being a finding of fact that everyone who was doing a particular job had the training in the training documentation, and there is no finding of fact to that effect in the paragraphs I've taken you to.
Okay.
And I observe it would be an odd consequence anyway, because we're looking at a relative period with different training documentations being amended or applying at different points in time, and to conclude as a fact that you assume that everyone had every bit of that training wouldn't be credible with the amount of material. So they don't make that finding of fact. That's the first point. So that's an error, we say, that it is simply the tribunal, consistent with the error that we've identified before, taking the wrong approach. And Mrs. Justice Stacey recognised that it was the wrong approach. But then at 170, I'm sorry, 169, on page 140, she turns to that second part, which is the forklift truck driver. And she identifies what the tribunal were contemplating, and we say rightly obligatory or mandatory training to do the job. And then at 170, she says if there were tasks other than forklift driving, for which any of the comparators require a license, registration certificate, or confirmation of training of some sort, that the tribunal had overlooked, these were exactly the type of matters that the tribunal said it would reconsider. I've not studied it in minute detail, but I understand from the parties that this has been addressed in the reconsideration judgment Appendix 7, which has a section on induction training, but if not, it's a matter that can perhaps be raised at the disposal hearing. Well, we say, well, that's wrong. It's not, if the tribunal have failed to make findings about something on which they have directed themselves they need to make, and the evidence was there for them to make the findings upon it, it's not a reconsideration point, that's an error on the face of the tribunal judgment. And on reconsideration, I think it's said against me, well, you should, as she invited you at disposal, have raised this point. And we did at first raise it, but of course the obvious answer to it is, well, you didn't win on this appeal, she's dismissed it. So I couldn't, on the jurisdiction of the EAT, have it looked at. And there is some reconsideration by the tribunal, but not as extensive as the schedules that we'd identified as being the evidence that one dealt with.
Can I just be clear about this? I've forgotten what the rules are exactly about reconsideration. I mean, on the face of it, it seems very odd for the appeal tribunal to say, well, there may be an error here, but the tribunal can reconsider it. And therefore, I needn't deal with it. Is that even a proper approach?
Well, I would say not, because I think the answer on reconsideration, it's true that there's a broader power consistent with the interests of justice for reconsideration for parties, and the previous constraints are slightly looser. And in fact, the judgment that we passed up for the training without going into it looks at the current formulation of the rules in relation to reconsideration, which have changed. But ultimately, we're focused on what the EAT had to do here, and we say it's not the existence of reconsideration, even though the tribunal was saying we're finding these things, but we contemplate people may apply for reconsideration.
Though, couldn't you, where the tribunal has, by the time of the appeal, conducted a reconsideration,
yes,
and has corrected the error.
Yes.
No idea what formally the EAT should then do, but in the sense it's academic, whether it allows the appeal or dismisses the appeal, but clearly nothing will flow from it.
Yes.
And that is actually what is being said. It's not saying this can be considered as a later reconsideration, it's saying it already has been.
Well, although from our perspective, they've included in their first reconsideration judgment some induction training for one of the comparators, but they don't deal with all the mandatory training that we scheduled in relation to our skeleton argument in the way that we've described. So we're left with a position whereby there's material that the tribunal on their own direction should have made findings about, and after two reconsideration judgments, they still haven't determined all of that process. And from the perspective of the EAT, what the right conclusion was for Mrs. Justice Stacey to conclude that that was an error of law to have directed it. Well, obviously we say it was an error of law, a primary error, just to rely on the training material. But even if that's wrong, there's a freestanding separate error here that having directed itself that it would decide the mandatory training, there was an error to fail to make those findings. And that required the appeal being allowed, and then on remission, it could have been dealt with by way of disposal, to say, you need to make the findings in relation to these matters. But because she's taken the wrong approach there, that isn't open.
Formally, I imagine when she says at 171 ground A1G5 is dismissed, that can be revisited at any point until the disposal. There's no order generated by that. The order occurs at the disposal hearing.
Yes, but the disposal hearing reflects the grounds.
Well, I understand that, but it would never be open. So, well, I know I said dismissed, but I've heard submissions. I haven't yet made a final order, and actually, I will say allowed.
Yeah,
I mean, I'm just you were taking a technical point about you couldn't revisit it because she said it's dismissed. But
well, it's not so much a technical point I'm taking; it was taken against me because we included in our draft disposal order a recital to have the tribunal's attention directed to what she'd said, and that was objected to certainly by the Harcus claimants. So in the eventual disposal order, it wasn't included. So it's not like I gave up the point. It's I hit a brick wall. I'm going to move to the scope appeal. I'll endeavour, if my timetable position was 11. I think I'm going to need till 12 to complete it. But it's dealt with extensively skeleton, but I want to pick out some key points. I'll say I'm going to need. It's obviously a matter of indulgence for the court, not my need.
Well, does it cause any difficulty to the respondents?
Short answer, no.
Not for me, provided Mr. Reed accepts that his time for reply may shrink to accommodate extra time.
That is the inevitable consequence
Yes.
of me doing that. So I acknowledge.
Well, carry on.
I live in the world that will exist then. So scope appeal, in our skeleton argument, we deal with from paragraph 8 on page 36. And there were three original appeals. Two of them being consolidated as the first appeal against the tribunal's first judgment and case management order, and then the second appeal, the one against the substantive judgment we've been looking at of July 2024. All of them in the procedure had to go through the SIFT. But in the current EAT practice, that might be in some cases dealt with as a paper sift. On occasion now, the tribunal's process in EAT is to hold a preliminary hearing to determine whether or not grounds should progress. This was a slightly unusual preliminary hearing because all the parties were invited to attend in relation to submissions about it. And there was argument about what grounds of appeal should proceed or identified grounds of law. And the appeal judgment here is a judgment of His Honour Judge Taylor, which was his judgment of February 2025, and you find it in the core bundle, volume 1, and it starts at page 78. The judgment is the 5th of February.
So that's tab 8.
I'm sorry?
Tab 8.
I'm sorry, I should have said tab 8.
Oh, that's fine.
And he outlines the background of the proceedings and then systematically looks at the grounds of appeal for the purpose of this hearing. But the critical point of his reasoning is at paragraph 21. And he refers to the EAT practice direction and says that it generally requires grounds of appeal should be short and focused and clearly assert errors of law. Sections 3.9 and 3.10 require that grounds of appeal which assert perversity or procedural impropriety must provide full details. Section 3.10 includes the heading procedural impropriety and any material procedural irregularity. This requires particularity of each dispute rather than provision of examples. In any event, I consider where it is asserted that an error of law resulted in erroneous factual determinations, it's important that particularity of the errors are set out. Tesco has the resources to provide the required full details and is to be limited to the specific challenges advanced in the grounds of appeal, absent any successful applications to amend. Now, the approach that Tesco's have taken, we say consistent with the practice directions and the law, is that our grounds of appeal had outlined the legal errors, which were errors of approach.
Can we see an example?
Sorry?
Where do we find your grounds of appeal to the EAT that is on a Judge Taylor?
Yes. So the grounds of appeal in the amended format for the EAT, you find in this bundle,
Tab 13.
and you find tab 15, page
13.
189, I think is the.
There's 13.
I'm sorry, tab 13, is it? On 189.
Well, there's two grounds of appeal, two amended grounds of appeal. As you explained, there are two appeals.
Yes.
I can't remember which is the right one. You just tell us.
I was he applies the same rubric to both of them. I've just taken you to one as an example because I was asked for an example, and so I've taken you to the amended grounds of appeal on the second substantive judgment, and you find those at 189.
He applies this general proposition you've taken us to, I think, in the case of 3 grounds of appeal, of which not all are now relevant. That's right. Can we look at it in relation to one of those?
Yes, certainly. Well, so yes, so yes, 198 is an example. So this is, it was a ground relating to the comparators being required to carry out mental arithmetic. And as part of the specific details of the comparator's job description, it referred to some of the comparators having to use mental arithmetic as part of their job. And the tribunal's approach was to conclude, and you can see it in the ground of appeal at paragraph 49, that because a reasonable employer would have allowed comparators to use a mobile phone or provided them with a calculator, that wasn't a requirement and not part of their work. And at 50, this is where you see his approach taking. To illustrate it, we gave an example. And that was in one particular comparator. The same error was evident in other examples of comparators, but we only gave one example. And the effect of the decision of His Honour Judge Taylor was to say, you are limited to the example. That's the only finding of fact that your appeal can address. And so the net result of that was, we say, an absurdity that Mrs. Justice Stacey allowed this ground of appeal and remitted back the particular position in relation to Mr. Todd, but that's corrected, but because approaching it in the way that His Honour Judge Taylor did, the other examples of that particular exercise in these examples of comparators using mental arithmetic and the tribunal not taking that into account in relation to their demands remain in the judgment as part of the judgment because they haven't been successfully appealed, even though the EAT judgment indicates that that was an error of legal approach. So we're left with a judgment that has parts which are on the decision of the EAT transparently wrong, but have not been appealed because of this constraint. The other example...
Could we at some point, not now, just have all the other instances to which this error applies?
In the skeleton argument, we deal with this at it's paragraph 8.7 on page 38, and the references there point to Mr. Pratt. I won't take you to...
Okay, if they're there, that's what I wanted to know. So I just want the answer is there in paragraph 8.7. Okay.
Can we find? I mean, is the appendix the new appendix that it was sought to add by amendment? Is that helpful? Does that do that job, or does that do something different?
What's probably clearer, I mean, we made an amendment. What's clearer is that is if you look at the last page of our skeleton argument, page 50, because obviously these are freestanding grounds of appeal in themselves, and we appeal the scope judgment. If you look on the last page at subparagraph B, we actually set out there.
Sorry, the reference you gave before 8.7 frankly doesn't do this, but you're saying that
page 50 sets out. Now, what that doesn't give you is page references in the judgment, or indeed necessarily in the job descriptions as to whether they're in the bundle or not. But all of those there are individuals where the issue of mental arithmetic formed part of their comparator work, which at the moment stand with that reasonable employer approach is an error, adopting the Taylor approach.
so not expressing a view about whether you should have done that. What you could have done is in your grounds of appeal given a version of this.
Originally,
Yes, or amendment, but yes, the version that was before Judge Taylor could, if you had chosen, have included 11.3D.
yes.
Yeah,
Well-
I'm just that you say that does the exercise which Judge Taylor said should have been done, but you say didn't need to be done.
Yes.
Yeah, okay, thank you.
And obviously I've picked that as an example because it's nice and clear to see in the appeal. But obviously you can look at that and say, well, that was a relatively small, narrow table. Of course, he's also applying it to for example, another point where the tribunal took the approach that if there was an obvious fact, they simply articulated it to be obvious, and there wasn't a need to make any finding in relation to it. And we gave examples of that, but again, we were constrained to those, even though the tribunal had used that rubric.
Can we just show me the ground of appeal?
The ground of appeal of that will be, that's ground A2 G1C, I think. So if you go, it's page 191. Do you see little c?
Where?
At the bottom of the page.
16C.
Yes, so ground one had three subparts to it. Little c was, yet further in places the tribunal has concluded the facts are obvious. obvious facts, if relevant, required to be identified, but the tribunal did not always identify the facts. See, for example, paragraph 67 of paragraph 25. Further, alternatively, it's often unclear whether a matter which the tribunal considered to be obvious is a fact which should be taken into account in assessing EV or not. See, for example. So we were, as we understood the rules, giving examples to demonstrate the error of law, but His Honour Judge Taylor says, well, you are limited to those as your challenge. So there are many examples of obvious being used in the pages of the findings. And of course, it's a point that Mrs. Justice Stacey made. If their mindset is if something obvious, we don't need to make a finding about it. I don't know whether there's something which they thought is obvious, but didn't feel the need to make a finding because it was obvious.
So there were latent findings, potentially.
Yes, and that's a point that Mrs. Justice Stacey made. But she was constrained by His Honour Judge Taylor's order. So the only points that we were allowed and did succeed upon were the examples.
And is there a similar exercise to the one you showed us for your previous instance, where
there is, but it's much broader.
but I'm not myself, my lord, my lady, asked you to be taken through it, but just give us the reference.
So if you look at page 50, again, if you look at little c
Page 50 of what?
of our skeleton argument,
Okay.
do you see, in relation to ATG1, the one that I just taken?
Yeah, that's what you were asking the order to be.
Yes.
But what I'm trying to say is there somewhere an example of what you say is every time where they've done this? They've fallen into this.
There is a document that we've assembled, as I understand it. Sorry? There is a document doing the best we can. It's not in the bundle, but there is a document doing the best we can, identifying how many occasions.
That's not been. It's not in any of the pleading. Actually, we're not produced for the purpose of this appeal. I just understand what this document is.
It's a document that we've prepared that haven't put in the appeal bundle. I don't think it had been completed by the time of the appeal bundle. Going through, remembering that we're not just looking at one judgment, we're looking at 5 judgments spanning many pages.
I understand. I just wanted to know what it is.
Yes, it does exist. So if and obviously there may be a point of disagreement between us as to whether or not it's accurate or not. But if the view was that we were right on this point, but the disposal had to have greater precision, then that could be on the point of disposal dealt with by a precise document. But our fundamental error is that His Honour Judge Taylor was wrong to take this constriction on the rules because it wasn't present. And it said against me, well, effectively, you need it in your notice of appeal to have every single fact finding that you said had been tainted by the legal error articulated. And we say that's not consistent with the rules and not consistent with the statutory jurisdiction of the EAT. And I said, just so you know, those two are the grounds that we succeeded upon. This appeal impacts on the way that the EAT appeal worked. But in relation to this appeal, 2 of the grounds that are the subject of this appeal are also within the frame of His Honour Judge Taylor's order, and we deal with that paragraph 8.9 on page 39 of our skeleton. They're grounds 3 and 4, the last 2 that I dealt with. If you recollect, ground 3 was the not the agreed fact point, failing to accept agreed facts between the parties. We hadn't identified every single incidence of that. And ground 4, the failure to make findings on the training actually received. We hadn't identified every single item on the notice of appeal where there'd been a finding. These were, and our position was, these were errors of law in approach. We weren't focusing on, in a classic perversity appeal, a lack of underlying evidence. We were focusing upon the consequences of that approach. And that, we say, is consistent with the jurisdictional position of the EAT. And if you look at our skeleton argument, page 40, paragraph 9.1, we refer to section 21 of the Employment Tribunals Act, and you find that in the authorities bundle, and someone will give you the tab, but it is page 34 in the authorities bundle. So it'll be volume 1.
Tab 3.
Thank you, I'm grateful. You see that the jurisdiction of the appeal tribunal, so that's the Employment Appeal Tribunal, from tribunal to tribunal, is an appeal laid to the appeal tribunal on any question of law arising from any decision of or arising in any proceedings before and or under or by virtue of then or respective acts. So doesn't say judgment or order. It says any decision, any question of law arising from any decision of or arising in the proceedings. So in the jurisdiction, we read the jurisdiction as saying you can challenge the error of law in approach. You don't have to say, here are all the individual fact findings that we say are erroneous here. And I won't go through them, but at 9.2 in our skeleton argument, we refer to the rules of procedure. I know Lord Justice Underhill will be very familiar with the rules of process, in particular from the Employment Appeal Tribunal rules from '93, but they specify the format of the appeal, but they identify only the grounds that need to be articulated of how the tribunal erred in law. So there's no constriction there about the identification of facts. And at 9.4 in our skeleton, on page 40, we go to the relevant practice directions for the EAT, all of which are to the effect that you should be succinctly articulating in a few words the error of law. So all of our grounds were identifying the error of law with the exercise of examples. And at page 41, we address the fact, and again at this is paragraph 9.8, and over the page at 10.6, we address the fact that His Honour Judge Taylor refers to the rules about perversity and the guidance in relation to procedural impropriety. Our perversity was not a classic perversity of saying they found X, having had this particular point of evidence. The perversity was the perversity in the perverse approach of applying the law. And actually, it wasn't the primary point. It appears as perversity in the alternative. The framing of the grounds of appeal is always about the error of law in approach. And
So
impropriety...
So you're saying it's not perversity in its strict sense?
Yes.
You're just saying this is an error of law?
Yes.
Yeah.
And impropriety, obviously you'll be familiar that's mainly concerned with the situation where you allege bias. And if you're alleging bias, the practice guidance makes it clear that you need to be specific of setting out why. We weren't alleging bias. To the extent that we rely upon procedural irregularity, it was about the fact that all the parties progressed the litigation on the basis of evidence of what was done, and then the tribunal took the direction of looking at training documentation. It's a point of law. So we say that he was wrong to address that. And then finally, Elias got an argument at page 44, paragraph 10.9 through to 10.20. We deal with the cases that my learned friends rely on, and they all reflect a proposition that I don't disagree with, which is it's quite clear that you don't appeal for redundant purposes on the judgment. So if there's something in the judgment itself, a particular finding that you are unhappy with, unless it impacts upon the eventual judgment or decision, the courts don't entertain an appeal. All those are examples of circumstances where in the findings, the appellant disliked a conclusion that the tribunal had come to that may impact upon them in other litigation, but they weren't actually challenging the eventual decision. That's not this case. We absolutely are challenging the eventual decision. That doesn't mean that we had to identify it in the minutiae of individual facts. I think that's my time up, and that's all that I wanted to say. I'm very grateful. Thank you.
Thank you very much. Yes, Mr. Brown.
My lord, if you'll just bear with me for a few seconds to rearrange the furniture.
While that's going on, did you want the transcripts in hard copy?
If they're ready, they might as well be handed in. I've got one. Thank you. Yes.
My lords, my lady, as you know from yesterday, there are two groups of claimants represented before you in these appeals. One represented by, abbreviating the full names, Harkus, and the other by Lee Day. I act with Mr. Butler for the Harkus claimants, and Mr. Jones and Mr. Blake, and Ms. Barrett in writing for the Lee Day claimants.
Is there any science as to which claimant is in which group, or is it just who signed up with whom?
Well, in terms of which individuals ended up in which group, that was presumably a matter entirely of their choice. What was then done with them, I'll come to briefly in a moment. We, as in on behalf of the Harkus claimants, led for the purposes of the stage 2 process and continue to lead for 3 sample claimants and Lee Day for another 3 sample claimants. And you heard a little yesterday about how the tribunal has approached matters. There are all number of job roles that are in play. They've been divided into 3 tranches. We're only dealing with tranche 1 at the moment, and that contains 3 job roles. Customer Assistant Express. You heard about Ms. Garrod a little yesterday, and Ms. Williams. There is Customer Assistant Nights and Customer Assistant, I'm going to be reminded by Mr. Jones, replenishment?
Yeah.
Yes, Customer Assistant Replenishment is the 3rd. Then there are another relatively small number agreed for tranche 2, and then everything else is going to be in tranche 3. You've also heard something about the comparators and about distribution centres. Tesco operates fresh distribution centres, as they're called, which deal with chilled things and in some instances frozen things, so fresh produce, for example, and also ambient distribution centres. 4 comparators were chosen from fresh, 4 from ambient, and the Harkus team took the lead for the fresh distribution centres, and the lead 18 for the ambient distribution centres. So that's how things were divided up for the purposes of the stage 2 process. In terms of these appeals, as you know, you have two appeals. There's what's been termed the scope appeal, which is the appeal against His Honour Judge Taylor's judgment from the 10th of February of last year. And there is what is variously being referred to as the stage 2 appeal or the substantive appeal, which is the appeal against the judgment of Mrs. Justice Stacey from, it was handed down on the 1st of August of last year following a hearing in the middle of June. We, as in the Harcus team, will take the lead in this hearing on the scope appeal and grounds 3 and 5 of the substantive appeal.
Round 5 is, in fact, the scope appeal in disguise.
Indeed, yes. I was going to say that there will be some logic to it, which may not appear immediately obvious, but it hopefully will during the course of submissions. Mr. Jones and Mr. Blake will then take the lead on the remaining grounds, that's 1, 2 and 4 of the substantive appeal. On behalf of our respective clients, it may be that he wants to make some brief supplementary submissions on my points and vice versa, but we'll deal with that as we go. In terms of timing, we're a little bit behind where we anticipated being, but we don't anticipate that will be a problem, other than potentially for Mr. Reid in terms of his time for a reply, but I don't anticipate it. We will get even close to the full court day tomorrow. So if that provides you with any reassurance,
So you and
well
Mr. Jones, between you, are expecting to finish what time tomorrow?
Well, where are we? Coming up to 12. I anticipate I will finish probably middle of this afternoon, and I'll leave it for Mr. Jones, but I think from previous discussions, he will finish sometime tomorrow morning. So we're well on track to finish well within the listing. As you know, my lords, my lady, both of the appeals before you concern what's being referred to as the stage 2 equal value process. Something that will perhaps be more familiar to some of you than others. I'm going to deal with the scope appeal first, so reversing the order that Mr. Reid took his submissions. I can explain why if it will assist, but I'm not sure it makes much difference. It's the earlier judgment, it's the earlier appeal, and logically we think it goes first. I'm going to follow the order of the submissions made in our skeleton argument. I'm going to try to avoid A, trespassing on Mr. Jones's territory, and B, repeating things that are in our skeleton, which I know you'll all have read.
Yes.
I apologise in advance if and when I fail to do one or both of those. Yesterday, you were taken by Mr. Reid to some of the legislative provisions concerning equal pay and equal value in particular. I'm going to take you back to some of those in a little more detail because they're relevant to both of the aspects of the case that I'm dealing with. You were taken to tab 4 of the authorities bundle, which is extracts from the Equality Act, section 64 and 65. And you'll see that to many the familiar structure. Section 64 essentially applies the requirements for equality of terms. That's in broad terms section 66 to 70, including the potential material fact of offence. It applies those requirements where the claimant and a comparator of the opposite sex are employed doing equal work. And then if one goes down to page 75, we have section 65, which Mr. Reid took you to yesterday, which tells us what equal work means. And for our purposes, we're in 65(1)(c). A's work is equal to that of B if it is of equal value to B's work. And then subsection 6 tells us when work will be of equal value. Little a, neither like work nor work rated as equivalent, but B, nevertheless equal to B's work in terms of the demands made on A by reference to factors such as effort, skill and decision making. Where an equal pay claim raises a question of equal value, specific rules apply, again, as Mr. Reid took you through to some extent yesterday. The current rules are in Schedule 2 to the Employment Tribunal Procedure Rules 2024. For your note, and in case you want to look at it, it's tab 11 of the authorities bundle, but for our purposes, at the relevant time, the rules are in Schedule 3 to the Employment Tribunal Constitution and Rules of Procedure Regulations 2013, which are at tab 6. Starting at page 84, and if you go down to page 91, my apologies, you'll see the start of Schedule 3. As Mr. Reid took you to yesterday, Rule 1, amongst other things, contains a number of definitions, including the question, which is a phrase used later in the rules, as we'll see. The question means whether the claimant's work is of equal value to that of the comparator. And we've already seen from Section 65 of the Equality Act what equal value means in this context. Rule 2, general power to manage proceedings. Rule 3, conduct of stage 1 equal value hearing. And various options for the tribunal. One of them is to strike out the claim, 3.1a. One of them is to determine the question, so the question of equal value. Little b, the first part. Another is to require an independent expert to prepare a report on the question. And then little c, if the tribunal has decided to require an independent expert to prepare a report on the question, fix a date for a further hearing, which shall be referred to as a stage 2 equal value hearing. And as we know in this case, the tribunal did appoint initially 2 and now 3 independent experts to provide assistance, and after a number of adjournments, we ended up with the stage 2 hearing starting in March of 2023. If one then goes down, please, to Rule 4, towards the bottom of page 92, one has, under the heading Standard Orders for Stage 1 Equal Value Hearing, and here are set out with some, one might say, rather optimistic timeframes, certainly in the context of this case. Standard orders, albeit the tribunal can, if it considers it inappropriate, make other orders or not make these orders. And it's in mandatory terms, as you'll see from the beginning of Rule 4.1. The first couple, A and B, are to do with identification of comparators. Little c is to do with the respondent being required to grant access to the respondent's premises to allow the claimant and representatives to interview comparators. And then we come to the question of written statements. Little d, the parties shall, before the end of the period of 56 days, present to the tribunal an agreed written statement specifying little Roman 1, job descriptions for the claimant and any comparator. 2, the facts which both parties consider are relevant to the question. That is important, as I'll come to shortly. And little Roman 3, the facts on which the parties disagree as to the fact or as to the relevance to the question, and a summary of their reasons for disagreeing. And then little e, provision for further disclosure of statements, and little f. Again, another stage for statements. This one, at this time, facts and issues on which the parties are in agreement. facts and issues on which the parties disagree, and a summary of their reasons for disagreeing. It's clear we say from those provisions that at this stage, what the parties are being required to do is set out in writing facts which they consider are relevant to the question, and facts on which they disagree, either as to the fact or as to the relevance to the question. It's a two-part disagreement process, as it were. Carrying on in the equal value rules, Rule 5 is to do with involvement of independent expert in fact-finding. And we come to Rule 6, which is conduct of the Stage 2 equal value hearing. 6.1, it has to be conducted by a full tribunal, and at the hearing the tribunal shall, little a, make a determination of facts on which the parties cannot agree which relate to the question, and then shall require the independent expert to prepare the report on the basis of facts which have at any stage of the proceedings either been agreed between the parties or determined by the tribunal. And that's then referred to as the facts relating to the question. And little b, fix a date for the hearing. And then it goes on to provide that the only facts on which the tribunal shall rely at the final hearing are the facts relating to the question, as just defined, and so on. There was, in one of the many earlier appeals in this case, a question as to whether relate to the question in 6.1a of the equal value rules meant the same as relevant in Rule 4. Answer came there, yes, it does. Again, I don't have the relevant judgment in the bundle. We can provide it to you if you think it necessary, but I don't hear any disagreement from my left. Preempting to an extent things that I'll come to in more detail shortly, but in terms of the conduct of the Stage 2 hearing, the only function of the tribunal at Stage 2, apart from case management, fixing a final hearing and so on, is to find facts. The tribunal makes no other substantive decision at Stage 2 of an equal value process, apart from fact finding. What Rule 6 requires the tribunal to do, we say, is to resolve disputes as to the fact of facts or the relevance of facts, or sometimes both. And you'll have seen in the extracts from closing submissions that you've been taken to by Mr. Reid, in various instances, objection is taken to something that one or other side has put in, and in the column summarising the reason for the objection, sometimes it's a factual objection, as in this didn't happen. Sometimes it's a relevance objection.
But you're saying both are properly within the what the tribunal has to decide.
Yes. Yes. And Rule 6 does not, we say, limit the tribunal's power to manage its own proceedings, to further the overriding objective, the familiar rules and the tribunal rules, including, we say, departing from facts agreed by the parties. And we say that applies both to the fact of the fact, but certainly to its relevance, where the evidence presented to the tribunal and or the tribunal's decision as to the correct legal approach warrant it.
I just understand that. Clearly, in the ordinary case, arguments simply agree that this particular task was done, whatever the issue might be. That logically doesn't mean that they also agree that it's relevant. It will be perfectly legitimate, wouldn't they, to say, well, we're not sure we don't believe this is relevant to a job evaluation, but we'll agree is it what happened, and then we will argue at a later stage whether it ought to be taken into account in determining the value of the job.
That would be one approach, yes.
Well, would it be the right approach? You might get cases, mightn't you, where exactly this this sort of dispute came up. You'd say, well, this doesn't represent a demand of the job or whatever, but
yes.
we're happy, but it makes sense for us to agree the facts. At what stage under the scheme of the regulations does the issue of relevance fall to be determined?
At stage 2, at the stage 2 hearing, albeit in this instance it was
the
reserved.
Expert will have winnowed out anything that the tribunal decides is irrelevant.
No, the tribunal decides relevance. Again,
That's what I'm saying.
yes, and the tribunal
So the
decides.
independent expert gets a product which only has relevant facts in it.
Yes,
But that doesn't alter the fact that the parties can agree facts without agreeing their relevance.
yes.
Yeah. Okay, thank you. I'm sorry to be so.
No,
laborious.
not at all. I mean, there are a number of possibilities. The parties can agree that a fact is a fact. They can agree that a fact is a fact, and EV Rule 4 that they consider that it is relevant to the question. Certainly, in terms of relevance, that we say does not bind the tribunal to agree that it is relevant, because the question of relevance to the question is a question of law, and that's for the tribunal, not for the parties. And that's foursquare in ground 3 of the substantive appeal, and I'll come to that in more detail a bit later.
Sorry to interrupt.
Not at all, my lady.
Can I just understand your submission about what Rule 61A means?
Yes.
One way of reading it is to say that it only gives the ET power to make a determination of the facts on which the parties cannot agree.
We don't accept that is what it is doing.
Why don't you accept that?
Because what it is doing, when you get to a stage 2 equal value hearing, there will be facts that are disputed. You've seen Rule 4,
Yeah.
the parties are required to set out in writing which facts they disagree, whether as to the fact or the relevance. What Rule 61A is requiring the tribunal to do is to resolve all of those disputes, because otherwise you would be left with unresolved disputes and not a comprehensive set of facts as found as to the fact and the relevance to be provided to the independent experts. It would leave loose ends, and the whole point of stage 2 is to come to a definitive fact-finding result, which is then referred to the independent experts for their input. What 61A is not doing is limiting the tribunal's power, which it would have in an ordinary case, we suggest, where you may have parties who, for whatever reason, purport to agree that a particular fact was a fact. Once the tribunal has heard the evidence, we say it would be open to the tribunal not to accept that agreement.
How do you get that out of the language of 61A?
Well, because 61A is mandating the tribunal to resolve disputes. It is not limiting its power otherwise to do what it would otherwise be able to do in any other case.
That's not how it's phrased. It says, make a determination of facts on which the parties cannot agree. I'm just trying to understand how your submission fits with the language.
Well, may I deal with relevance first?
Well, I'm not asking you about relevance. I understand the point you're making about relevance. I'm asking you about facts.
Yes.
And facts which are agreed.
Yes. Well, 61A does not say make a determination of facts on which the parties cannot agree, which relate to the question, and nothing else, or only make a determination of facts on which the parties cannot agree.
I see. So, okay, all right.
But it continues. Shall require the independent expert to prepare the report on the basis of facts. And then there's two alternatives. One is either they've been agreed between the parties or they've been determined by the tribunal. Now, those look like two different buckets. They look like things the parties have agreed and things which have been determined because the tribunal is required to make determination of facts on which the parties cannot agree. You say there's a third bucket, which is that there are facts which, despite the parties agreeing X, the tribunal determines to be Y.
Well, not X, at least.
Not X.
But the first part of 61A requires determination of facts on which the parties cannot agree.
Yes, that's perfectly straightforward. Yes. And we know from Rule 4.1f that the parties have to tell the tribunal, here are the facts on which we're agreed, and here are the facts on which we're disagreed. And it has to give summary of their reasons, but it divides facts into those on which we're agreed and those on which we're disagreed. And then 6.1a says the tribunal has to decide the ones on which they're disagreed. Well, all that makes perfect sense. What it doesn't say, and the tribunal has to decide other facts. I mean, it simply doesn't say that. And you say, well, there's nothing saying they can't decide other facts, but it looks very odd.
Well, the second part of 6.1a, where it is referring to requiring the independent expert to prepare the report on the basis of facts which have, at any stage of the proceedings, either been agreed between the parties or determined by the tribunal, is not limiting the tribunal's determinations simply to the facts which the parties cannot agree about. As a matter of language, it doesn't do that. It's facts which have, at any stage of the proceedings, either been agreed between the parties or determined by the tribunal, and one might add, including facts as to the fact or the relevance, where the tribunal does not accept the parties' agreement.
Okay, let me ask you something else, because I think I asked Mr. Reid this. Leave aside this particular rule. Just look at general procedure in the tribunal or indeed in the civil courts. Take a perfectly straightforward action in the civil courts. The claimant pleads the facts which it seeks to rely on in asserting some claim to relief. The defendant pleads which of those are admitted and which are denied and which are not admitted. If a particular fact is admitted, the usual consequence of that is the claimant doesn't have to lead any evidence on it, because it's not an issue. And the purpose of a trial is to resolve the matters which are an issue. Are you saying that in an ordinary action, the court could say, well, I know this has not been disputed on the pleadings, but I don't think the parties are right. I'm going to think that something, I'm going to find as a fact something which neither party is contending for. That seems very odd to me.
Well, certainly in an employment tribunal.
Well, you say employment tribunals are different from the civil courts.
Well, in the sense of no rules of evidence, for example, and informality.
It's to do with pleading.
It's to do with pleading.
But it's to do with what is the function of the tribunal. Because as I say, I would take the view that in a normal civil action, the function of the court is to resolve the issues, and the issues are those which emerge from the pleadings. And the whole point of having a system of pleadings is the claimant knows before they come into court what things they have to establish and what things are not in dispute. And I would find it bizarre that the court could say, well, I know this is not in dispute and I haven't had any evidence because no evidence was necessary. But nevertheless, I'm going to find something which is neither party's case. Indeed, I think there's authority saying that's improper. But you say it's different in a tribunal. But why? I mean, the purpose of tribunals and courts is to resolve parties' disputes, and they resolve disputes by resolving what is an issue between them.
Can I approach this with an example?
Yes,
perhaps.
that would be helpful. Thank you.
Imagine the tribunal is faced with perhaps an unrepresented claimant, as is perhaps the case in the majority of cases, and as it's also quite often the case, an unrepresented respondent, and claimant, I hesitate to use the word pleads because quite often
Puts in the ET1.
puts in the ET1, thank you, a number of contentions which the respondent, for whatever reason, does not challenge. That, we say, would not preclude the tribunal at the hearing from hearing the evidence and testing the evidence, as the tribunal often does, particularly with unrepresented parties, and reaching conclusions that are not consistent with the way the matter was put by the claimant and not challenged by the respondent. It happens on I imagine, a daily basis. To bring it into the context of this case, if, for example, the respondent said in relation to one of the claimant job holders, one of the sample claimants, that the environment around her workplace was particularly, I'm paraphrasing, I hope reasonably accurately, was particularly pleasant because there was a duck pond in the village near the shop. That's not a hypothetical example, it is from one of the job descriptions in this case. And say you had a different claimant, unrepresented, doesn't understand the EV process or the question of relevance and so on, and simply accepts that, we say it cannot be right that the tribunal at the stage 2 hearing of that case simply cannot say, well, I'm sorry, with the best will in the world, that is not something that is relevant to the question.
We're talking about facts, not relevance.
Suppose, and it's, I entirely understand that you have to operate the tribunal's procedures for claimants who are typically not represented, and very often respondents are not represented by professionals either. And one has to make accommodations for that, as indeed district judges in ordinary civil courts do up and down the country every day of the week. But that's a bit unrealistic in this case, where parties are represented by legal teams of the very highest calibre, and that it's not necessarily the case that people who have agreed a fact, there is a duck pond outside the shop, the tribunal can say, well, we don't think there is a duck pond there. It just seems very, very bizarre that you could end up in that situation. I understand it's a different question as to whether that's of any assistance in evaluating the value of the work. But to say that the tribunal can go behind something which is agreed as a fact by people who know what they're doing seems to me to be a very odd proposition, and I don't see it reflected anywhere in the rules you've shown us. And for my part, I would need some persuading, but that's a proper thing for the tribunal to do. Certainly in a case like this, where you can't accuse the parties of being poorly represented.
May I?
Just from my experience, this would say that even in, of course, the case is at its strongest against you here, because there's a very specific rule, and because in this particular case, but in probably most big equal value cases, the parties, well, most equal value cases full stop, the parties are in fact professionally represented. But even in not in this situation, although of course employment judges have to be flexible in their application of the rules, the basic principle behind the rules remains the case. And if a claimant, if a respondent seeks to argue something which they have never disputed before at the hearing, they will not be allowed to do so, however user-friendly the tribunal, if the respondent would be prejudiced, And an employment tribunal would, in practice, say, well, there has to be an amendment. It can all be done very informally, but they have to be permitted to put this in issue, which they haven't put in issue before. And that the idea that somehow, because it's the employment tribunals and weak parties are often unrepresented, basic principles don't apply, is not the case. The AT spent its life saying that.
I've set out our position. May I come back to it possibly later? But in the context of ground 3 of the second appeal, the substantive appeal, which is where this point is particularly relevant, our position is that it doesn't matter, because if you actually look at what the tribunal has done, it's all dealt with either on the basis of relevance, or it's been corrected if there was a problem in the first place by reconsideration, or it's not clear what Tesco is complaining about. So lest I divert myself even further from what the points in this case actually are, I'll move on if I may. Just want to say a little bit about where we are in this case below and how we've got there. And you will have gathered, I'm sure, that it's been a fairly long and somewhat tortured process to get where we are. And I know Mr. Reid yesterday took you through some of this, and I mean no criticism of him, but he made a number of slips in terms of dates of things and who made applications and so on. So for the transcript, if nothing else, if I may just go through a little bit of the history. But as you will have picked up, I'm sure, the first claims in this matter were issued in February 2018. And at an early stage, as I touched on earlier, job roles were split into 3 tranches, sample claimants were selected, comparators were selected, and at stage 1, which itself was some years ago, independent experts were appointed. As I said earlier, we now have 3 independent experts to assist the tribunal. The stage 2 hearing came on in March 2023, and with 1 or more breaks, it took place over some 7 weeks, and the evidence finished in May of 2023, and then, as you'll have seen from the first judgment, if nowhere else, there was then a further hearing in July 2023. Again, Mr. Reid's taken you through this, so I won't take you to the documents unless you want me to. The first judgment, as we're calling it, was promulgated on the 12th of July 2023. That's tab 16 of the core bundle for your note. There is then what's been called the July CMO case management order from the 26th of July 2023, following a further hearing on the 20th of July. That's tab 17, and then tab 18 is the second judgment. That's the 600-odd page one, which was promulgated nearly a year later, 4th of July 2024. Just pausing there, and just to explain a little more about the structure of the tribunal's approach. Mr. Reid referred to an anchor comparator. I think it was Mr. Jones.
Yes.
What the tribunal has done in the stage 2 judgment, and indeed in its refinements to it later on, is not really to have an anchor person, but to have an anchor task, if I can call it that. What the tribunal has, the structure the tribunal has adopted for both claimants and comparators, but it's particularly clear from Appendix 8, which is where the 8 comparators are discussed. They've looked at particular tasks that were undertaken by the job holders. And for example, my Lord Justice Nugee was discussing with Mr. Reid what happens in a warehouse. It is a little more complicated than that, but the essence was right. Things come in, goods in is the term. Things are sorted into cages, assembly. Things go out, loading. Those are the three key functions, and within each there are all sorts of subtasks. For example, as part of goods in, there is physically getting the things off the delivery lorry, there is checking them, moving them to the right place for the assemblers, and so on. But what the tribunal has done is, for the first individual it gets to who does a particular type of task in either fresh or ambient DC, if we're looking at the comparators, it has made findings of fact about the tasks that that individual did. Mr. Jones, we've heard, did, I think, mostly, if not entirely, assembly. Others did a variety of different things. And then when it gets to another comparator who did the same thing in the same type of distribution centre, essentially it says, well, see what we
Mr.
said
Jones.
before.
Yes.
And similarly, where you have, I mean, there are differences in terms of loading, for example, between ambient distribution centres and fresh distribution centres, in part to do with the nature of the things that are being loaded. What the tribunal then does is deals with the first person who does that task in whichever type of distribution centre they do, and then later on it makes findings about the material differences between them, which we say is a perfectly sensible way of approaching it.
I haven't quite understood why there are 8 comparators. Look, we were told, and it seems to be true under the Act, that it's for the claimants to choose their comparator.
Yes.
So you can choose more than one, can
Yes.
you? Is that so? You say, I want to compare myself with these 8 people.
Yes, in theory, you can choose as many as you like.
Yeah.
But for reasons of practicality, if nothing else, after much discussion and input from the tribunal, we ended up with 6 claimants and 8 comparators. And I think it was in part so that we could cover both types of distribution centre
Yes.
and all the tasks within the distribution centres, all the material tasks.
But all you have to do is find somebody whose job is equal in value to yours, and then you can ask for equal pay with whoever that comparator is.
Yes, but in many cases, including this, it's not a case of well, I'm working in this shop, and through that door is the warehouse, and I know the people in there.
Yeah.
The process of getting disclosure and information for the purposes of identifying the comparators was a pretty
Torturous one.
tortuous one indeed.
My Lord's point is right and important for the bigger picture, that you can have a situation where you choose 2 comparators, graded the same, because they are graded the same as I understand it, and therefore paid the same. Yes, no, I don't know. James is nodding.
Some yes, some no, I think.
So the different distribution centres have a different structure in terms of what bonuses, etc., might be available, but the essence is wherever they are, they're
Yes, that's what I thought. So you have 2 people graded the same, but because grades are quite capacious, as you say, there are different tasks and different individuals who within them will do different groups of different, you have different weighting in the kind of tasks they do. They may all do all of them, but to different degrees, or some of them may only do some and not the others. It's perfectly possible that you will succeed in showing equal value with one comparator but not the other.
Yes.
And then you get a really messy situation because the grade the claimant will be equated with that grade, but that person may not be typical of the grade as a whole. But that argument is fought out, if at all. I don't know where the Lords ended up on this. It's a long time since I've had to look at it. That argument is fought out at the general material factor stage. Is that right?
That will be certainly one point at which. Yes.
So Wayne Jones, who you've heard quite a lot about, he is atypical in the sense that he only does assembly. That makes him attractive to the claimants as a comparator. because as Mr. Reed put it, points means prizes. So the more different things you do, the more skills are required, the greater the demands are likely to be. So someone who is simply doing one function is a very attractive comparator. So from the respondents,
attractive from the respondent's point of view.
from the claimant's point of
From the
view.
claimant's point of
Claimant's
view.
point of view.
So far as the respondents are
Because
concerned,
they're being, let's say, overpaid.
They're being paid for doing a
they're going to-
single task as opposed to other people on the grade who are being paid to be capable of doing three different
correct.
tasks.
So they're getting the same that people who are doing more functions and thus arguably are more skilled, who have more points, to take Mr. Reed's approach, are being paid. So in relation to Mr. Jones, what's argued for him is that he is atypical, and that it has two consequences. So they say he is an extraordinarily talented assembler. He can assemble in a way no one else can. It was more or less literally put in those terms.
He thinks ahead, unlike other people who just slavishly follow what the computer
He's
says.
just allowed to do what he wants.
Yeah.
And that has two consequences. One is the one that, Lord, you've just averted to, which is that in due course it might be something that they want to talk about in terms of whether there's a material factor defence. But they also say he's so extravagantly gifted that the nature of the work he does is different to what other assemblers do. So it's being argued at both points, both at this stage, the
Yes,
stage 2 fact
I
finding,
see
but
that.
also later at material
I
factor.
see that. Well, that's helpful. It's only very much deep background to what we're actually having to decide today. But speaking for myself, it's useful to see how it all fits in.
One might perhaps rhetorically ask how one knows what Mr. Jones is thinking when he didn't give any evidence, including a witness statement, but that's another point. And for example, one of the comparators for whom we were responsible was a Mr. Young, who was a large part of his work drove a forklift truck. One might think he's at the other end of the scale potentially in terms of attractiveness for the claimants, but is paid more.
What's of interest to me, I've exhausted my interest.
Well, I'm going
Yes.
to raise one other thing which is of interest to me. That the independent experts have to decide whether A's work is equal to B's work. Do they, by reference to a number of factors, do they produce a score and say your score is 87.5 and yours is 92?
Yes, they can
Yeah.
do. They're left to their own
It's
devices.
up to them.
So sometimes you just get a report that says A is plus, B is minus. Sometimes there'll be a fixed score, but they're entitled really to approach that in any way they think will be helpful.
And you can get a situation, can't you, where, I think I've seen this, suppose neatly all the different factors and the weightings and so on they employ means you have a scale of 100. They could say, well, in terms of equal value law, LORE, any job between 80 and 90 is of equal value because we can only be able to be broad brush. So you don't necessarily win by you storing by the claimant. I'm losing myself in my example, but it can be if the experts think it right, you can introduce an element of approximation in their judgment of equal value.
Yes, that's right. I should also say, without wanting to be too pedantic, the independent experts don't decide equal value. They provide their view of equal value. The final question is always one for the tribunal.
And we were told by Mr. Reed that in cases like this, the parties would instruct their own experts. So presumably you can have cross-examination of experts at the final hearing. Yeah.
And the worst case scenario is you end up with bring in a passing expert, they produce a report on the independent expert's report, then on each other's reports on the independent expert's report, then on the independent expert's reply to the various reports. So it is still possible that there is a long and complex and
It
expensive
sounds
way.
terrible, but an awful lot of money is at stake, so it's
There
not
is.
surprising.
Yeah.
Thank you.
Going back to my what was intended as a relatively brief canter through the background, we have got to the point where the first three of the tribunal's judgments stroke orders following the stage 2 hearing have been promulgated. The first judgment, the July case management order, and the second judgment from 4th of July 2024. And that is, at that point, the outcome and the only outcome of the stage 2 process in the form of those decisions. And those are the decisions that are ultimately the subject of these appeals. As you know, Tesco first appealed, technically it was 2 appeals which were consolidated against the first judgment in the July CMO in the latter part of 2023. That's been referred to as A1 or Appeal 1. And to pick up a point made by my Lord Justice Underhill yesterday, we have always said those appeals were premature because they don't actually tell you what the outcome is. They tell you what the tribunal at that point was saying it was going to do in terms of approach. There was then another appeal against the second judgment, which again we've said is the time at which an appeal should have been brought, or at least the first appeals should have been amended to add the specifics. That has been referred to as Appeal 2 or A2. Again, as you know from Mr. Reed's submissions yesterday, there have been 2 reconsideration judgments which made some changes, particularly in the first one to the stage 2 fact finding. Again, I'm not going to take you to them unless you invite me to, but they're tabs 22 and 23 of the supplementary bundle. The first reconsideration judgment was not appealed by anyone. And insofar as Mr. Reed was discussing with you yesterday the fact that it incorporates videos and so on, that's never been something appealed. It's not the subject of this appeal or any other appeal. The second of the reconsideration judgments was the subject of an appeal, and that's the judgment from His Honour Judge Taylor from last Thursday. The hearing was in early February, and those appeals were allowed, and the matter was remitted to the same tribunal to continue the reconsideration process in a number of respects, but a relatively minor number of respects. It's a very limited. It was a very limited appeal and a limited remission.
I thought we were told that all proceedings have been stayed by order of Mrs. Justice Stacey.
Yes.
So the remission is on hold, as it were.
The remission is on hold. The disposal order of Mrs. Justice Stacey is on hold. The IE's process that they started last year, if not the year before, is on hold. Everything to do with stage 2 is on hold at the moment, pending your judgment on these appeals. The last bit of the jigsaw, as it were, I was going to refer you to was that Tesco have made a third reconsideration application last year following Mrs. Justice Stacey's judgment. That was, unlike the first 2, not something that the tribunal had, I was going to say hinted at, suggested is probably a better word.
Invited.
Well,
Maybe
yes.
not. Sorry.
Yes. No, not probably more, even more accurate. And it's an application made expressly on the back of Mrs. Justice Stacey's judgment. The claimants have not made any further reconsideration applications, and again, that is sitting in the tribunal's in tray, waiting the lifting of the stay.
It seems slightly odd that you can have 2 routes to challenge a decision, one by appeal and one by reconsideration, proceeding at the same time. I mean, in a sense.
Well, in the ordinary case, one has a limited time to make a reconsideration application, and one would hope the tribunal would deal with it pretty promptly.
Yeah.
Whether you would get the answer to it before the 42 days for an appeal is a different matter, and typically one may put in a reconsideration application, you don't have the answer, you put in a protective appeal, and then depending on the outcome of the reconsideration, you can withdraw the appeal.
Uncommon situation in the AT, as you say, you had to put in a protective appeal because the reconsideration doesn't stop time running for appeal.
Indeed.
But as a case management matter, the AT would probably, unless the reconsideration was to take some time,
Yes.
Administratively or formally stays.
Well, one of the many difficulties in this case in terms of timing is that you have a judgment from the 4th of July 2024 and reconsideration applications being made a year or more later. In respect to the first two sets of applications, I think that the tribunal expressly extended time for them. It hasn't done anything with the third because the whole thing is stayed, as I say, pending the outcome of these.
One of the many oddities about this case is the Employment Tribunal, as you say, whatever word one uses, has regarded reconsideration as really as part of the toolkit. Well, we're going to decide some things, but we can see there may be arguments about them. Anyone doesn't like them can apply for reconsideration. That may not be completely fair, but there does seem to be an element of that in their thinking, which I've not seen before.
Well,
on the other hand, it's a very unusual piece of litigation, so it may actually have been quite sensible. I'm not expressing a definitive view about it.
Well, and in some, my apologies, in some respects, as I'll come to in the context of Ground 3, it has been helpful because it's resolved one of the things that is complained about in these appeals. But it is one of the features of the tribunal's approach that Mrs. Justice Stacey has made the comments about in her judgment that she did.
The more orthodox thing will be to say, here's a point on which we are not yet certain or we need further help, and you don't decide that point until you've had it. But there you are.
Yes.
No point in going over all this.
Indeed, and
so one can't resist doing so a bit.
Well, on this side of the court as well. But it's one of the express features of the equal value rules that the independent experts have the power to ask the tribunal to revisit things or make further findings or and so on.
Yes, but that rather argues against the ET doing it anyway.
Yes. Just wanted to touch on one thing that Mr. Reid said yesterday, which was, again, I paraphrase, there have been an awful lot of appeals in this case, but they haven't all been by Tesco. Well, and this was in response to what has been said before on this side, which is that this is not a respondent that is demonstrating particular keenness to get on with this case. And one can imagine from its perspective why that is. It is true that not all the appeals have been by Tesco, but the vast majority of them have. For example, the judgment from Judge Taylor from last week, all the parties appealed against the same thing on the same basis. So that is one example where it isn't just Tesco appealing, but as I say, for the vast majority they have been the appellant. Their position before Mr. Justice Stacey was to support the suggestion that the parties should be ordered to reformulate the job descriptions. That's part of her disposal order, in light of the tribunal stage 2 findings. And as part of that, it was said, in essence, that, well, it'll be fine, it won't jeopardise the final hearing in February 2027. You will have heard yesterday from Mr. Reid, and it's something that was said in I think the last EAT hearing in February. The respondents' approach is now that there is no prospect of that final hearing taking place in February 2027. So one faces the prospect that no claimant will have a final result of their claim until probably more than 10 years after the claims were issued. And even then, on Tesco's position, as I understand it, the result will only be for the 6 sample claimants and it won't resolve anything for anybody else. Not, as I say, an approach by a respondent which is keen to resolve these claims as soon as possible. But as my Lord Justice Nugee, I think, said a short while ago, stage 2 is stayed pursuant to the order of Mrs. Justice Stacey, and there we are. And indeed, it has been since last summer. It was first, the stay was imposed first following the hearing in June. That is tab 77 of the core bundle for your note. It was then reiterated in the disposal order, which is tabs 165 of the core bundle. I don't want to preempt Mr. Jones's submission, but I don't imagine he will disagree with me in saying that we have never suggested, we didn't suggest below, and we're certainly not suggesting now, that the tribunal judgments with which you're concerned are anything like perfect. I don't say this purely for comedic effect, or even what the parties were expecting or had asked for. But that does not mean, as Tesco characterises it, that the judgments are the result of fundamental wrong turns, or, as they say at one point in their skeleton argument, that the EAT has already found that the tribunal went seriously wrong.
It's a slightly odd submission to accept that the judgments are what the parties expected or asked for, and at the same time not to say that things have gone fundamentally wrong.
Well, not what the parties had asked for in terms of a tabular form of the type seen in other mass claimant equal pay claims, as some of which examples were appended to Mrs. Justice Stacey's judgment. But the point is, just because the parties said, please will you fill in the final column of this table, again I summarise I hope reasonably accurately, that does not oblige the tribunal as part of its fact-finding process to do that. It's entirely up to the tribunal how it does what it is required to do under the equal value rules and the form in which it chooses to do it. It is right that the EAT, Mrs. Justice Stacey, has allowed a number of the specific grounds of appeal by Tesco and has remitted some specific matters to the Employment Tribunal. But they are specific matters, and if you look at the disposal order, tab 165 of the core bundle, again, I'll take you to it if you'd like me to, but I don't need to make the point good. It goes into some great detail about precisely which paragraphs of which job description are to be reconsidered. Sorry, reconsidered is the wrong word because it has a specific meaning. Looked at again by the tribunal on remission. They are specific grounds on specific parts of the judgments. It is also right that Mrs. Justice Stacey, supported by Tesco, has ordered the parties to turn the existing judgments into a different tabular format. But she also said during the course of her judgment that what the tribunal has produced is workable. And the independent experts have agreed that they can produce a report based on what they have, even if it will take them some time and it may require them to seek input from the tribunal to resolve further queries. That's tab 46 of the supplementary bundle.
Can you give me a quick look at that?
Page 788. I think it should be tab 46.
Seven eight eight is
788 is the end of the letter, which starts. It's a fairly lengthy document. Yes, 777 is the start. It's the covering email, January 2025, and then 779 and following to 788 is the.
So when it says January 2024 at the bottom of 788, that's
it's
wrong.
it's a typo. Yes.
Yes. Thank you.
So you were paraphrasing para 4.1.
Yes.
paraphrase is literally correct, but I'm very enthusiastic about it.
No.
The purpose of this is really say, do we really have to do this, isn't it?
Well, it's saying we can do this if you really want us to, i.e. we can work with what you've given us, it'll take us a long time and it's going to result in lots of cross-referencing and
See what it says.
yeah.
Do you have any idea or submission as to what a very considerable time means?
well,
We're
what
told a normal report in a case like this can often take a year.
Yes.
Is this very much longer than a year?
No.
No.
the as Mr. Reid correctly said yesterday, that the indication was they thought it would take them a year.
Thank you. And does that mean that if we dismiss the appeal and the IEs do what they say they could do, you still wouldn't get an answer by February 2027?
I suppose it may depend to a large extent on how much they've done already, because they started the process before they were told to stop. And if the net result of all this is essentially they're working with the same material they had with some tweaks from reconsideration and so on, then it may be that work is not entirely wasted. We don't know how much they've done already. It seems unlikely, but I can't say for sure, I'm afraid.
So what they suggest in paragraph 3.3 is that the ET should reconsider its position about how this is all presented and direct the parties to produce final definitive EVJDs incorporating facts found at stage 2. So they're effectively saying it's pretty unmanageable as it is, and there are all these caveats above about attribution of facts and all complex strings of references. Okay.
Well, we would characterise it as it is manageable. It's just not as manageable as it would be if it were in a different format. And essentially where we are now is that Mrs. Justice Stacey has imposed that process on the parties, albeit that is stayed pending the outcome of these appeals. As
Yes,
are other
and to be
matters.
fair to you, they say their problem is all about format. They proceed on the assumption that if you look hard enough, you will find in all this material findings, not presented in the most helpful way, but findings which can be put into a table.
Yes.
With caveats.
Yes, quite. But they're saying instead of us having to do that, it'll be much easier for the parties to do that. Square brackets, they don't actually spell this out, with any further reference to the ET where they can't agree what the ET has found.
Yes, my lord.
And that's really effectively what as you say, what Mrs. Justice Stacey said was the best way forward.
Well, indeed, it having been suggested by the lead A claimants and supported by Tesco. We disagreed in large part because we could predict that February 2027 was not going to happen if we went down this road. But
your position was that, which may, to some extent, you would say still be borne out by what has happened when you tried it on one claimant comparator pairing, that there were major disagreements as to what the ET had found. Have I remembered that right?
well, as part of the process, there is a disagreement between the claimants and Tesco as to the approach in terms of how much. What Mrs. Justice Stacey has directed us to do, in essence, is where there is reference to training material, to produce a succinct summary in the tabular form. There is a fundamental disagreement as to what that requires. As I understand it, Tesco says basically you have to put the whole training document in. The claimants say no, you don't. You have to do a succinct summary. I'm not as close to that aspect of the case as others, but yeah.
Just to clarify, there is a difference in approach between Tesco and the Day claimants. We agreed as to their way forward, Mr. Reid says, on his part reluctantly in front of the AT. The question is now when you go to the training materials and you find what the job requirements are, do you only copy into the table consisting of a list of points of disputes, the findings that relate to the specific dispute, which is our approach, and that will leave us, we say, with the table we all thought we would end up with when we started, which is a list of disputes with a determination in the final column. The approach taken by Tesco is to say, well, if they have incorporated a whole document, they're incorporating every finding that may be deduced from that document, whether or not it relates to a specifically identified dispute. So we must add more rows to the spreadsheet to make sure that we can include all of those additional job facts. And we think that's not what the AT had in mind, but we are confident the AT will tell us fairly shortly, because we've both written to the AT and asked them for clarification, which is the correct approach. So it is true that there is a disagreement as to how we go forward. I don't think anyone at any point in this case sat on the other side of any of the benches has managed to come up with an approach that we weren't able to find some way of disagreeing about. So that in and of itself does not cause me any panic. But the EAT will, we hope, shortly put the cherry on the cake, as it were, and tell us exactly now what it is we need to do. If it's any help, we submitted a sample table to them, which took our approach, not to them, to her, and Mrs. Justice Stacey gave us a gold star and said, yes, that is what I had in mind that you would do, but there is now this dispute to resolve.
I can see the time. I'm about to move on to a different topic. I'm not sure if...
Should we break there then? Resume at 2 o'clock.
All rise if able.